All right, it's 7 o'clock, so let's get started. So the first part of this meeting is a workshop, and that's for the council to do its planning. And then after that, we will hold a regular meeting. We're guessing that's 8 o'clock, but that's not a guarantee. And so let's get started and see what we can get through. In terms of roll call, I know there are two absences. Amber and Dan are out of town and excused. I see all the other council members, so we have a quorum. I see the city attorney, and I see the city administrator. Is there anyone else from the city online? I don't think so, right, Nick? Or is there? Do you have a colleague online?
No.
Okay. All right, so let's first look at 248 Tyranda. We have an amended concept plan to take a look at, and how do we want to talk through that?
I'm happy to, Mayor, provide an overview and introduction, unless the applicant's engineer is, actually they're not here in the audience, I don't know if they're online. Ben,
Yes,
do we
they
have
are,
someone
Mayor.
who's going to present
Yes,
on
I'm here.
behalf of the applicant?
Yes, Karen Labruto.
So, Mayor, this is great, Karen. So Karen Labruto is the applicant's engineer from Labella Associates, who is representing the applicant with respect to the concept plan. This is a property that's located in the Fishkill Creek Development District, the FCD, and the applicant's materials include a cover letter that Karen is going to summarize for us, and as well as building plans and the site plan. And there's a request to amend the concept plan to remove the required non-residential and instead replace that with residential. And if the council, the next step would be for the council to adopt a resolution at your next meeting tonight to refer that to the planning board, who would determine themselves to continue to be the lead agency and then provide a report and recommendation back to the board. That's sort of just an overview of what we would imagine is tonight's discussion point. And then after the applicant's representatives makes a more detailed presentation, I'll provide some further comments.
Okay, so what I think I heard you say is our next step is a referral to the planning board.
Correct.
Okay. All right, so does the applicant want to go through this?
Yes, I
Yes,
think
if you don't mind, I'd like to make a presentation. May I share my screen?
Sure.
I think it's disabled for, oh, there we go.
I'm giving permission now.
Okay,
You have permission now.
wonderful. Okay, can you see my screen?
not at present, but now we can, yes.
Wonderful, okay. Let's see, top to top, there we go. Okay, as I mentioned, my name's Karen Labruto. I'm a senior planner with Labella Associates. I'm here representing the applicant in their application to the City Council for amended concept approval. As you know, this project has been long in planning and in action for the redevelopment of the northern portion of the Tuck Industries manufacturing site. This revised concept plan changes the use of Building 100 from a 2-story office to a 3-story multifamily apartment building with parking and other site plan changes. So a little project history. April 2014, a secret negative declaration by the planning board was granted for a 100-unit multifamily residential development. The concept plan and special permit approval was granted in August of 2014. In January of 2015, lot consolidation site plan approval was granted for the planning board for the 4 residential buildings with 100 units and associated amenities. In 2017, the City Council adopted zoning amendments to the Fishkill Creek Development Zoning District, which no longer required the special permit for multifamily dwellings. And then in June 2019, the planning board granted a secret negative declaration for amended site plan where Building 100, which previously had been residential, was changed to office. The coincident amended site plan and subdivision approval was accepted by the planning board in 2020 in April. And here we are today. Our current action is that the applicant seeks to once again go back to residential use of Building 100 and to make some modifications to the parking. So in detail, it would be that the 25,400 square foot 2-story office building would now become a 3-story residential building with 36 units. There will be 164 total parking spaces, and this includes 4 dedicated spaces for Greenway Trail parking. So as you know, the project is on Tioronda Avenue. It's in the Fishkill Creek Development Zoning District. You can see that buildings 200 and 300 are substantially completed in construction. Utility installations are almost complete as well. Again, the proposed amendment here would bring Building 100, which was formerly approved as an office building, 2 stories, to a 3-story residential building. And again, it would include some changes to the parking. So let's talk about the public benefit. As you know, the project includes the Greenway Trail. In this new concept, we are revising the Greenway Trail easement to include access to the full island. In addition, as I mentioned, there's 4 public parking spaces which are dedicated to Greenway Trail users. ADA accessibility has been dramatically enhanced here. Prior approval of this plan included many steps. The steps are gone, and there's an elevated pathway out to the trail. Building 100 will add 36 units to Beacon's housing stock, and that includes 4 workhouse housing units. We will need a waiver as written in the code to remove the non-residential use from the project. This is required to be possible with public benefits. As I've just demonstrated, there are several here. Furthermore, office space is, the demand is greatly diminished. The site's far from Main Street, and the applicant has sought out commercial tenants to no avail. So here's the site plan. I'll zoom in a little. You can see that, as I mentioned, Building 100 will now include 4 workforce housing units. Here's the elevated Greenway Trail, the ADA accessible access to the island. As I mentioned, the Greenway Trail easement will be revised to include the full island. Parking in this area has now been removed. Let's go to the next sheet. So here's buildings 200 and 300. We're including some lighting bollards at the rear of the building. And finally, here are the 5 land-banked parking spaces. So we do have some current challenges. As I mentioned, buildings 200 and 300 are nearly complete. Utility installation is partially complete. For Building 100, the foundation's been completed and underground utilities at significant expense to the applicant. The completion of Building 100 requires confirmation on the use, which has implications on the building framing. Office and residential buildings have different building framing. And the applicant respectfully requests granting of certificate of occupancies from the building inspector for buildings 200 and 300 while we determine the final use for Building 100. So as a next step, just to run through them, we are hoping that you will refer the application to the planning board and provide clarification on certificate of occupancies for buildings 200 and 300. We are making the application to the planning board. We anticipate that the planning board will declare intent to be lead agency and conduct the seeker review. And finally, we will be making an application to the county's Department of Health for increased water and wastewater. And that's the presentation. Thank you.
Okay. Does the applicant want to add something? Great. Let us know who you are.
My name is Barry Cohn. I'm the developer at 248, and I appreciate hearing our situation. And if there's any questions or anything that I can elaborate on, why and how I'm not very good at this. This is not my presentations is not my strong holds, but if there's anything that I can answer, then we can do that.
Thank you. So, Mayor, there are, in fact, you want me just to sort of outline some of the next steps. I'll go through the procedural bucket and then the substantive bucket. So in process, it's for referral of a concept plan to the planning board, city only, doesn't require referral to the county planning board for a report and recommendation. When that comes back, you would schedule a public hearing. And then after the public hearing, you would decide whether or not to grant the concept plan amendment. If the concept plan amendment is approved, they would then proceed to the planning board for site plan approval and any variances, if any, that would be required. That's sort of a procedural pathway. The substantive questions before this board are, I believe, fourfold. The first is, does this board wish to grant a waiver of the requirement of providing non-residential? And so as Mr. Labruto mentioned, that is found in section 223-41.14B. That's in page 29 of your agenda packet, 223-41.14B, and it's in the second half of that paragraph. Additionally, a minimum of 25% of the total development floor area shall be permitted non-residential uses other than dwelling units or artist-lived workspace, which must be built out before or concurrently with the residential development of the site. Less non-residential square footage may be granted by the city council when there are other substantial benefits, if you read on in the sentence. So really, there's three components there. You would be waiving the non-residential uses. You would then be allowing, the applicant has requested, that the COs can be issued for the buildings 200 and 300, which I understand are ready to be, or soon will be ready to be occupied. They're asking that you modify that condition so that they would be permitted to get COs for those buildings while there's discussion about what to do with building 100. And then if you decide you wish to waive the requirement of non-residential, they're then asking for you to accept that there's a public benefit, which they've described as the expansion to the Greenway Trail. You then need to determine, if I'm waiving the non-residential, what are we doing with that space and what is the public benefit? The applicant has proposed constructing additional residential units. There are two ways that would proceed. One is they could go to the ZBA and get a variance. The other alternative would be, instead of a variance, this code could be amended to allow for greater density when the board waives, the council waives the non-residential, and you would then be in control of what are the requirements if you wish to allow more density and more units, and you could tie that into your public benefit. Otherwise, that would go to the ZBA to consider whether to grant the variance for the additional units.
Could we also, if we were to take that route, adjust the percentage that's affordable within that third building?
You could, yes. I mean, I would say anything is on the table because you're being asked to waive something that is required and determine what is that public benefit. So, yes.
So, and let me also try to put on the table a little more background on this law. So, as I recall, the two steps are concept plan and then site plan approval. We actually used to have another step in the middle, but that's luckily gone.
The special permit from
Yeah,
the city
right?
council, yes.
And so our role is concept plan, which means we have to stay up at the concept level, right? So we're not working the details of what's the, what's the ramp to the island look like, or, those sorts of things, but rather, is the change in the concept plan, because we approved one some time ago, consistent with the one issue that's being raised here?
That is correct, Mayor. Yes.
Okay. And then we refer to the planning board for them to offer us an opinion on the concept plan change, and then it comes back to us and we go through our work.
Correct.
Okay.
And then it goes to the planning board for site plan approval, if it receives concept plan approval.
Got it. Okay. And I think what you're saying, and I didn't know this at the time we did this, that if the commercial component is waived, that doesn't go into the residential count.
Correct.
So it was sort of like we missed that, right? Because we allowed for the possibility that, could be that we won't get commercial this far away from Main Street on some of the properties. We got very fortunate with the old highway garage, because it's right adjacent to Main Street. We got 80% commercial.
Correct, and I discussed with the building inspector, Bruce, whether this language that allows the council to waive it and then require something else which is deemed to be a public benefit, that would be increased density. In our opinion, that may have been the intent, but that's not how it's written. So if you wish to allow more residential, either they go for a variance or the council would amend this code, and then you would have control of that and not the ZBA.
Right, because as I'm hearing it, what you're saying is, although we contemplated the ability to shift away from the commercial if it wasn't viewed as, viable and be replaced by residential, we didn't allow the residential count to go up.
Correct, there's no language activating that intent, if you will.
All right, so now I understand why you're saying we might want to amend this.
Yes.
Okay. Those are questions I have, because I just want to understand the context.
So you're saying, in terms of the residential count, the 36 is sort of the baseline? We're talking about going beyond that by some allowance?
Correct. The current density is, I believe it's 11 units per acre, and there's some deduct for environmentally sensitive lands such as wetlands and steep slopes. And as it is permitted, they would, of the 36 they're proposing, they currently would be able to build 4 of them. They would need a change in the code or a variance to build the additional.
So yeah, if I could add, I think that the current construction in the 2 buildings that are largely complete takes all the residential count,
All but 4, yes.
all but 4. So in other words, that second building was at 25,000 square feet.
I believe so, yes.
You can build 4, which I don't think was our intent, but that's the issue, right?
Correct.
Okay. Any other questions before we kind of dig into any of the kind of substance of the concept? Okay, so this would replace the commercial with 36 units of residential. I assume roughly the same size as the other units and fitting into the building envelope, et cetera.
Yes.
All right, and that either we would need to amend the law to correct the omission, or we just send it to the ZBA, and I think they would probably see it too. But either way, those are our 2 paths to resolve that. But that's not what we're addressing now. What we're addressing now is the change in the concept plan of removing the commercial and adding instead the residential, and getting the addition of greenway benefits.
Correct. I think that, right, in my mind, the first question is this board satisfied that the non-residential component is not feasible and should be waived? Second question then is, if it's to be waived, are you also comfortable with allowing the COs to be issued for buildings 200 and 300 when building 100 has not been built out? And if those first 2 are yeses and resolved, then you'd move to the third, which is, if we're waiving the non-residential, what is the public benefit we'd like to see? And maybe those first and third questions are sort of the same conversation.
Okay.
To that first question, I would be curious to understand more about what the difficulties that have been faced trying to get a commercial tenant have been. I know that sort of national trends were cited in the presentation, but I am sort of fundamentally concerned with making sure there are spaces for people to work within the city, if that is a possibility, which, you know, was the original idea.
Yeah, I mean, there's been like almost zero interest in office spaces at that location. I mean, the most we had is somebody would want to take 2,000 or 3,000 square feet, which is a non-starter for a 25,000 square foot building. It's almost guaranteed to fail as a commercial building. So, you know, everybody in the world basically is going to conversions from office to residentials. So if we would build this building, we'll end up going backwards at a later time. It just, to us, it makes no sense to do that. So we had zero good, and even the ones that inquired about the commercial was not tenants that most probably would qualify for a build out. So.
Right,
This is a
and
couple of years.
if I'm understanding what you're saying, you were pursuing not necessarily just office commercial, but other types of commercial tenants,
I mean, the
but
only,
ran into limitations with the building design?
that's correct.
Okay.
Can I get an explanation of just the baseline requirement that we had in the first place? What was the advantage? Why was there a requirement for commercial, from the city perspective? I'm really interested in the comparative benefits.
Yeah. So, at our first round, and you kind of heard the expert who spoke earlier, that we've changed the zoning a few times. The earlier version of the zoning was residential only, and then along the way, we thought the development of the city was far enough along that we also wanted to see if we could get some commercial, right? And so the thought was to add a commercial component, and that was the 25%. That was added most recently, but also with the relief valve of, if it doesn't work, then come seek, relief. I think the evidence now
Well,
in terms...
the benefit, though, just the benefit of commercial. I mean, we said it in concept, in abstract
that
terms,
would
of what is the benefit of having commercial?
Live, work, right? So you're creating a community that isn't just a residential community, but you're creating more where one could live and work in the same place.
Tax benefits, one versus the other?
Commercial would tend to be less of a burden on schools, although, what are the size of the apartments in terms of bedrooms?
Ones and twos.
Yeah, so what we have found in practice is most of our construction doesn't generate a substantial population for students. Where the school district gets it is from single-family homes, which is not what these are, right? So we've looked at evidence on the things that we've seen develop in our dense areas, and they tend not to be ones that have a ton of school-age kids,
Do we have, like, evidence of that documentation?
Yeah, so-
Yeah.
right? Yeah,
Where do we have that kind of evidence? I'm really
we'd
curious
have
to
to
see
ask
it.
our planner to get it, right? But that's available. We've been through that, so we're there. We can get that.
I would like to see that.
Yeah. Right. So, yeah, the evidence that I see is just the market right now. You know, I work in Midtown Manhattan. There's a ton of commercial space available, and you're seeing wholesale conversion of things like malls to residential, because what we're extremely short of in the region is housing, right? So I'm not surprised at all for someone to say there's difficulty finding large-scale tenants, especially off of Main Street, and it's much easier to build housing units right now.
Nick, do you have insight into the history of the Greenway Trail? Because I think there was maybe an initial approval about the Greenway Trail, and then that got switched when they actually started building. I'm trying to understand, the kind of language of the code is a substantial public benefit, which would not otherwise be required of the project, so the history of what was already part of the project for the Greenway Trail and what is changing.
Yep, so I think the only thing that, as I understand it, is being offered that is different from what was required, approved, and agreed upon is this connecting bridge from the trail to this island in the Fishkill Creek. That is being offered as a Greenway Trail public benefit. But the Greenway Trail, as presently constructed and recently amended by the Planning Board a couple months ago, was all consistent with the pre-existing approvals.
And Nick, I believe that the parking spaces were not required by code
That's correct, yes.
for dedicated to the trail.
Correct, thank you.
We're actually introducing two more components to public service that's going to be a public amenity, which is one at the dam. We're building something that we're just figured that out. It's not something that we actually put on paper yet, but we think it's going to be something that the public will have a great benefit from, as well as on a tree house that we're going to build something that the walkway trail will have access to, and people will be able to have that as an overlook, and as well as the island as well. So it's in my belief that the Greenway Trail will be identified with this project on a whole different level than it was identified until today. Till today is just you walking through, even though it stops at the end of our property right now and eventually will continue. And when that does go all the way down to the park, it will be tremendous. But me as a developer, I understand of what the Greenway Trail does for the city. So we're trying to put in as much as possible as amenities for the public, so the public actually uses it, not just it's there if it could be used. And it's a win-win for the property and for the city and for the people. So, and that's what we strongly believe that to be the fact, and that's what we're going to demonstrate on this property.
But these additions to the Greenway Trail are only if this change is made to residential, taking away the commercial requirements?
It will add some more dollars to it, maybe by the island, but the rest of the stuff, we're going to do it regardless. This is something we're doing, we're committed to do it, as just it's there to be done. And it's a cost, but the property is a significant enough property, and it's a beautiful property for not just residents to enjoy. And you know, as much as I come into Beacon and I go to the falls and just watch it is something that makes sense for everybody to be able to enjoy.
Just to clarify, though, just these changes to the Greenway Trail, these additions, these public benefits, you're going to do them regardless of the decision?
We're doing them as we're speaking right now.
Okay.
Yeah.
So
I mean,
this
at
is
least the
presented
one-
as if it was one contingent on the other. I just wanted clarification.
Well, it will help that we have, the other building clarified of what we're doing with it and underwrite it, but we're going to do that anyway. The answer is we're doing that anyways. We're still waiting for the island to see from the DEC of what we can do over there, so that's something we have no clarification yet. But as we work through Building 100, of what it's going to be, hopefully in that time frame, we'll get that all sorted out.
Two questions to follow up on that. One, with that island, is it above or below the 100-year floodplain in terms of, the longevity of this hypothetical public benefit? I'm sure that's part of the DEC approval process. Maybe answer that first, and then I'll ask the second question.
So the island is in the flood zone, and that's why we're discussing whether it's going to be elevated, what it's going to be built on, and that's why we're waiting for guidance to see. There's a couple of different methods of how it can be built, but it could be built. It's just a matter of it's going to be high or low. And it's going to be a combination of both of them, a high portion and with maybe steps going down to a lower portion. But it still remains, that's something we don't have any clarification. But what we did in the meantime is that in the site plan, the last site plan, we included that to be into the easement of the Greenway Trail. So it gives the Greenway at least that, while we don't have clarity of what we're going to do with it exactly, it's there to be done at whatever level we could possibly do it.
Yeah, thank you. That makes sense. The second question, and if you could answer this briefly, because this is sort of maybe getting a little off topic, but if you could briefly describe your working relationship with the Greenway Trail Committee, and let us know, what their feedback on this project is, if you've heard that.
I would just say that I believe that it's excellent. My relationship and their, but we align our ideology about it is about almost aligned as much as we've been in contact constantly, and everything that we want to do, we actually invite them to come down and take a look at it and take their opinions of what we should do. And we did a lot of things over there that was because of what their insight was of how to get it done. We took out all the ADA steps and to improve it for public use. And that was with Tom's and his team insight, and it works for both of us. That we both understand of what of the magnitude of the Greenway Trail is, and so yes.
Thanks. Can you talk a little bit about, I think there was initially a trail spur that was part of the approved site plan that then when the site actually started being built out needed to be eliminated. Can you talk a little bit about that and any relationship to this new proposal?
Yes, so there was one spur, and the spur went, this is when the Greenway Trail still had all these different elevations. So they had a spur that went I would say about 30 feet in towards the north side of the property. But when these couple of big storms happened in the last couple of years, so the last 2 years particularly, it would have been wiped out in even in the weaker storms, it would have been wiped out. That's when we repositioned the whole walkway to see that how is this going to sustain these kind of floods. But because of that, that's when we came up with the idea of the island and how to get something that's going to not just build it and just wash away and then where nobody's putting it back. That's number one. And number two, we did two different spurs on the northern end that actually goes in as more trailway than we initially had on the site. So I would say there is about an extra, about 100 feet or 150 feet of trail of spurs that is extra that wasn't included in the plan to begin with.
Great, thank you.
Okay, any other questions? Remember, we have a very limited decision we're making now, which is, do we refer it to the planning board for an opinion? And then comes back to us, where we then can have any further conversation we want to have.
Did
Is
they
that
also,
correct? Do I have that right?
That, as well as the request that there be some modification that we'd have to figure out whether that's done by resolution or by a change in the law to waive the requirement that the non-commercial be built before the residential is issued at
okay.
CO. And if there is interest in sort of allowing more residential, to give us direction to sort of look at what that language might look like.
So basically, you're saying, if it's sort of like splitting the project a little bit, right?
Yes,
And by splitting the project, we get 64 units of housing online.
correct.
Okay.
that's what I was just about to ask about, that CO decision, does that have to go to the planning board as well?
That
No.
does not, no. That rests with you. It's either in the form of a resolution or it may be a text change to the law.
And is there any downside to getting the CO so that these units could get online faster, or is there?
I don't think so. Do you see anything?
I don't know.
All right.
I think there might be some perception that this was not how the project was approved, and so I would like to have public input before we made that decision, but I don't think we're going to make a decision today anyway, even if we wanted to go that direction, we
Right.
wouldn't do that tonight.
That
so.
choice would also be part of a hearing process, right?
If we change the law, yes. If it were a council resolution, likely not, but you could put it to a public hearing, yes.
Or you could wait for the resolution until after a public hearing on the concept plan change.
Correct, yes.
Got it? Okay.
Yes, you could do it as part of your review of the concept plan.
Okay.
I'm just looking for a little bit of guidance that if you want us to do some drafting for us, to get my brain thinking about it.
Yeah. Yeah, I'm of the view that this is an omission of the law and that we should correct it. If that doesn't work for this particular applicant, I just as soon do it for the law, because the idea that if we have the right to waive the commercial, and yet if it goes from commercial to residential, all the extra space is basically for naught, which is a mistake, given especially now with our housing shortage. So that would be my preference.
I had two questions. Was it thought of to have a mixed use for this building instead of just all residential? Keep some office? And at what point can we say they should have more workforce housing because of allowing them to do this? Is that now or
The
later?
answer is now, yes. Now and later, but now would be the time to start the conversation, I would respectfully suggest, because then the developer gets some feedback and can respond to that, and the planning board might respond to that as well. But yes, you have the ability, you in essence have a blank slate. You have a building that the applicant contends is not going to be buildable, so you have in essence a hole in the ground and an incomplete foundation. So the question becomes, if you agree with that, what works best for that project as well as for the city? And what is that public benefit? So yes, you have a blank slate. If you think mixed use works and that's feasible and the applicant can respond to that, you should have those discussions now.
How many, so it's 64 units that are in building 2 and 3?
Yes,
Of
32 in
those-
each building.
Excuse me, 32 in each building?
6 of those are BMR units.
That was my 6, total 6 in each building?
Correct, yes.
6 total?
Six total,
6 total.
10%.
Yes.
Pam, just to follow up on the second thing that you said and what Molly asked as well, and a little bit to what Jeff said, I am certainly interested in seeing a higher percentage of workforce housing in these units to fill out the full public benefit of this change.
I agree.
I agree, too.
We can talk about exactly how much, but that is the direction I'd like to see us go.
So that would be in lieu of any Greenway changes?
Well, I'm not actually totally sure if the Greenway changes proposed, based on what Barry said, weren't already proposed as an alternative to the spur, so I just want to get clarity on that. And kind of, we talked about affordable
Yeah.
housing, and so this might be an opportunity to make some of that feasible. So actually, Barry, I put the question to you, if you think of more, I know that we're talking when we say more units, you're like, well, what does that mean? Like when you think of doing more units, workforce housing. I appreciate financially that changes the structure for you. Do you have any kind of questions or responses back to us as someone who would have to actually put this into action?
All right, so just to take it, I mean, this would automatically do 4 units on this 36 units. There would be additional 4 units as it is right now. These things that we're doing to the Greenway Trail are pretty hefty numbers. They seem like a little island, a little drift, a little thing, but it's a couple $100,000 for these public benefits, and plus the parking spaces that we're building additionally. These are, it's quite significant amounts. But nevertheless, these are all, we're trying to make this project feasible, that it gets to the end. It's going to be a beautiful project. And so, I think even with 100 units, it's still a very challenging project to make it pencil out feasible. That's the reality of it. I mean, a lot of it is, costs for what happened in all these challenging times that we had. A lot of it was in excavating overruns that were just ran substantially. So there's a lot going on in this project that's not just as simple as just saying, okay, but nevertheless, I'm listening, and I'm here to make it work, not to not make it work.
Great, thank you.
Yeah, Pam, I'm intrigued by your point about exploration of mixed use, some on-site services. We're talking about parking issues on Main Street and travel trip, from these locations. So if there's any services that could be provided that would be beneficial to the residents and generally to overall footprint, that'd be worth exploring.
Well, and even you had said there was one interest in office space. I mean, could that be considered, and then above, residential, to have that mixed use of the one building?
Most probably not, just because where the location is and the mix of it in that same building, I don't think at this particular site would work. It works more on Main Street, and we have in many other projects that works. The first floor retail, like we have retail on first floor would work. And could it work with another floor of office spaces? Yes, on a Main Street, yes. And when you're so far off of Main Street, it's just something that's, people don't want to have, I mean, there's such a thing as having an office, but people want to have offices where something that's happening. So I don't think it's going to work. But again, that was just an inquiry. It wasn't even something that would come to fruition.
Mm-hmm.
Yeah, I would suggest that council focus on the residential component, which we're incredibly short of. My one example of off Main Street office space is on Roundabout Avenue, which has never been very popular, right? We had a building there for some time, and I said I just don't think it works very well in a residential neighborhood. So I'm okay with that. I would also point out that we should be cautious about assuming that the applicant will do certain things that aren't in the approved concept plan from before or the site plan, right? That's strictly up to the developer to do on their own. I know he says he wants to do them, but I think we should be cautious about assuming that, right? So.
Nick, what does that mean our next steps might be?
Sure. So in the agenda meeting is a resolution referring the concept plan to the planning board for report and recommendation. You're also noting this resolution that the planning board should continue as the lead agency if the city council is not interested in doing that. The other thing you could add is to schedule a public hearing for August 19th, which would be the meeting after you get your report and recommendation. It would allow for you to receive public comments on this plan, if you wish to do so. Otherwise, the next step is just refer to report and recommendation. You would workshop it again. We would consider what changes to the code might be appropriate, and you would then, at your next meeting, after a report and recommendation of the workshop of the 19th, continue this discussion as to what waiver are you willing to do with respect to the non-residential, and what would you want in its place?
And the planning board, as part of its process, it doesn't have a formal public hearing as part of its recommendation back to us? Is that correct?
Yes, correct.
In that case, I'm certainly open to setting a public hearing for the 19th. I feel like this is a project that has gotten public input in the past, and so I would like to hear from the public. Maybe a miracle commercial developer will come forward. This is my dream. I appreciate you've done the work, Barry, so I'm not banking on that, but I think just getting the input of the public would be helpful, especially because the project's been going for so many years, and I know you've kept with it. I really appreciate that, and so getting the input of those who have followed alongside you, I think, would be really valuable.
And if you were to hold the hearing on the 19th, you could at that meeting split off the project in the sense that you could adopt a resolution allowing the CO to be issued for the non-residential, modifying your permit, or we could have a local law ready for that at that time also.
And then there's also the issue of amending the zoning.
Yes.
All right, so I'd like us to pursue that. What's the time frame for that, and how does that fit in here?
We would need to prepare that local law. You would have to workshop it. You would then have to refer it to the city and the county planning boards, and then hold a public hearing. So that wouldn't occur until your August 5th meeting. We could have that ready. You could refer it to the planning board for discussion at its meeting in August. So yes, that could then get back to you on for the 19th as well.
All right. And then I think if we're summarizing the input to the owner, it would be, yes, you've kind of proposed changes to Greenway, but you're also seeing interest in the council for additional workforce percentage for that new group, and would you consider that and kind of come back with, thoughts on what might work? Is that relevant? Is that pretty good for the council in terms of what we're asking?
Mm-hmm. Yes.
Okay. All right? Because we don't have to solve that instantly, right?
Correct.
Okay. Council, all right with those items to proceed and that input to the developer? Okay.
Yeah.
Yes.
Cool. Okay. All right,
Thank you.
thank you. So the next couple ones are yours, Nick. The first one is a proposed local law regarding eviction prohibitions.
Thank you, Mayor. So in the agenda packet is a proposed local law and a memo from our office discussing the New York State Real Property Law, Article 6A, which enacted a good cause eviction local law. You may recall the city itself had adopted a good cause eviction local law in 2022, but like other good cause eviction local laws in the area, they were struck down as being preempted, as our office had advised. And then in this past May, the state adopted its own version of the good cause eviction local law, and there were two provisions that local municipalities can voluntarily opt into. And our memo then goes forth and sets forth what those two areas are. The state law says that the municipalities are specifically preempted from modifying any other aspects of the good cause eviction local law. I don't want this conversation to focus on what is the good cause eviction local law, because that's advice that tenants and landlords should get from their attorneys, but we did provide you with some overview of that information, provide you with other links so that you could be familiar with, if you opt into the good cause eviction local law, what does that actually mean? Specifically as to the two questions for this council is establishing the exemption for high rent for housing accommodations and for small landlords. So the good cause eviction local law would only apply if the rent were below what the high rent is established, and if someone has a housing accommodation that is controlled by a small landlord. New York State has established that the percent of rent is 245%. In our memorandum, we provided you with a chart showing what for Dutchess County is the fair market value at 100%, and we've given you those rents for efficiency 1 bedrooms up to 4 bedrooms, and then we've given you the state default of what those rents would be. It's protected under the 245%. The small landlord exemption, New York State has established at 10%, at 10 units or more. So this would apply to any landlord who owns 10 or more units in the state. So if you have a unit that you have inherited from a family member up in Buffalo, that counts. If you are a 1% owner because it's with relatives or it's a family trust or something of that nature that you control, that would then count. So it's a very broad definition meant to be very inclusive. And so those are the two questions for the council. We've prepared the draft local law with the defaults established by the state, and in your agenda packet is a resolution scheduling that public hearing for, I believe, your August 5th meeting.
Nick, can you talk a little bit about what would be different for a landlord? So there, if they fall under good cause, the good cause law, and they had a tenant who was not paying rent, right now what they can do, or a tenant they simply didn't, who wasn't following the laws of their lease, right now that falls within good cause, but my understanding is right now a lot of times landlords essentially use the non-renewal as a way to not go through the eviction process. Is this law saying that if you fall under good cause, you would be more likely to have to go through the eviction process in order to have that tenant who is either not paying rent or not meeting the terms of the contract not be in your property anymore?
So I want to be careful, because I don't want to be offering guidance as to what the law says. I don't think the law goes as far as that. And on page 4 of our memo, which is page 35 of the agenda packet, sets forth what are the grounds by which a tenant may be removed only for the following good cause reasons. And it's up to the landlord to, when they plead their case and bring their eviction, establish that they're either exempt or that none of these good causes exist. So we have about 10 different bullet points. One of them is failure for the landlord to agree to reasonable changes to a lease or increase in rent. So as far as the ability to not extend a renewal, I'm not prepared to offer an opinion as to how that falls within, but it does not explicitly say that you must automatically grant a renewal.
Okay, interesting. The reason why I asked the question is because I'm of the mind that, as other small like us municipalities in Mid-Hudson Valley have done, is what is the downside to setting our small landlord number at any more than one unit? And so I'm curious to hear what is the downside for those landlords who currently fall between 10 and 2. So what are the added onus on them? So things like they'll have to sort of spend more time in court, sort of finances they might not have. And so I'm trying to kind of increase my own knowledge about how the process would work and change in this law, knowing that I think, because I'm very aware of the flip side of this, which seems to be I can't find an easy way in New York State to find how many units a landlord owns. You can look it up by property. That's right. Relatively easy. Leaving even LLCs aside for a moment, you can see who's there, and there is some LLC legislation that's changed somewhat recently. So I can see the argument for having as few units as possible to make this law usable for tenants, but I am really curious to learn the other side, which is what is the downside, the consequences for the many great small landlords we have in Beacon who I want to be able to keep doing what they're doing. And so just understanding those trade-offs is kind of where I'm coming from. And I say that not just to Nick, because he's sitting next to me, but to the whole council. That's just kind of where I'm coming from.
I would have two responses to that question. The first is that my understanding of the law is that it only deals with legal proceedings, which is something a landlord, if they are trying to evict somebody, would go through regardless of this law or not. It's just putting parameters around an existing legal proceeding that would happen no matter what. So I don't really see I guess I can hypothetically imagine the argument that it's an additional burden, but that's not actually borne out in the legality of the proceeding, in my understanding. And in terms of the other idea of the sort of on-balance downsides, I would just point to both the individual and community harms of evictions. There's plenty of studies that point to the well, what some people have described as a public health concern that evictions cause in terms of causing people to experience homelessness. Children in particular are disproportionately affected by evictions, and we can go into further detail about that, but I want to leave space for other folks to speak as well.
I would, again, I'm not a landlord attorney, landlord-tenant attorney, excuse me, but for example, our first bullet point, non-payment of rent unless the rent is unreasonable. Typically, if the tenant has to pay the rent, if they don't pay the rent, then you can bring an eviction proceeding. In this case, it's sort of now a second step where the tenant could challenge and say the rent is unreasonable and not pay that rent, so you would be in court where you otherwise might not be. And so that is something that is different from what currently exists.
I'm trying to understand why the state put in a minimum of 10 and, you know, gave us some flexibility, and then also set a maximum rent amount. And New York City did exactly the same thing in this legislation, and I'm just trying to understand that. I believe what the issue is for a small landlord is they don't have the deep pockets to go to court. And I think that the frequency of a small landlord using the eviction process basically precludes the eviction process, right? And I do believe that, because there isn't a huge lobby for, you know, homeowners of, you know, 4 units or whatever the is, right? The big lobbies are, you know, real estate and other things. And so somehow this got in there because there was a belief that this is harming that group. And I think the fundamental reason is that they're not going to go to eviction anyway because they can't afford it, right? And what they can't afford is to let a lease expire and try to get a tenant out that way. Because otherwise, you know, I don't think they have those sorts of pockets.
I think that being a landlord is a responsibility, and this is part of the liability that you take on.
Well, that's an interesting statement, but it's also for, you know, people who are self-employed. It's their only retirement income. And so especially when you're talking about rents at the 245% level, you know, those are folks who have tons more income. So to kind of argue that, you know, anyone who's a landlord has tons of income and anyone who's a tenant doesn't is not factual, right? And I think that's what the state was trying to take into account by setting a minimum of units. I think counting, it's not very hard to figure out how many units somebody's name is on in New York State, and I believe if you went to eviction, it would be on the owner to demonstrate what their number is.
That is correct, yes.
Right?
I'm going to ask a stupid question because I wasn't part of the good cause eviction before. The fair market rent, that 100%, so what is it saying, that they can't charge more than that? Or what is that number?
Can't charge more than 245% above the fair market rent. So each year, the county determines what is the fair market rent, and you cannot go 245% more than that number.
I thought you could go, but
I'm
you
sorry,
wouldn't
yeah.
be eligible for good
Yeah.
cause.
Sorry, yes, right. In
Right.
context of the good cause eviction law.
So
Thank
So
you.
it's-
using your chart, right, if I'm looking at a one-bedroom, it basically says if the rent for the one-bedroom is $3,500 a month, this law would not apply to that rent,
Yes.
right? And we have some flexibility to set a number above which it wouldn't apply.
To say it in slightly more layman's terms, I believe the intention behind this clause was to exempt quote-unquote luxury units from being subject to this law. And that's both on the tenant and the landlord side.
And I do not stand behind this as, you know, deeply scientific research, but I just went on Zillow and checked our current rentals against the chart that was provided, and I think we have, of the 50 that were listed, 3 were above 245 and seemed like they were more luxurious than the rest of them, whether or not they themselves would count as luxury. So I personally am fine with the 245 cap that the state law recommends.
I personally don't really see the need for the cap at all. My position from my perspective is that all units should be subject to this law, regardless of if they're quote-unquote luxury units or not. And that's not to necessarily, I know we've talked about focusing on people who are most affected. Mayor, you've talked about means testing for programs like this. It's not so much on the renter side that I think that the limit isn't necessary, but on the developer side, I'm concerned that by having a cap, we're incentivizing landlords or developers to only build luxury housing because they're slightly less regulated.
Good point.
I don't see that in the least. The issue at the high end is you're offering a benefit to people who don't need it. And that basically imposes a burden on the housing market that is not a necessary benefit that needs to give out. What needs to happen in the housing market is we need to build housing, right? We don't need to have a portion of the economics necessary to build housing to protect luxury apartment owners for their rents not to go above $4,500 a month when they're willing to pay $4,500 a month for a two-bedroom. That makes no sense whatsoever in terms of the economics, right? I would much rather see us provide that sort of benefit or limitation to get more housing at the right price point, right? And the way that it happens is someone builds a penthouse and uses that. Let's use the example of someone who was here, right? If they were to build a few luxury ones that are high price points in the same building, they might come back and say, I can afford to do 20% inclusionary at workforce housing because I can make the numbers work. If we put a limit on the top end, right, you basically preclude those economics. And that doesn't make any sense with respect to our goals. So I'm okay at 245%. I'm struggling to see why we need to provide a benefit for someone who's going to pay $4,500 a month for a two-bedroom and wants to be protected.
So, Mayor, what you could do is go with the default in the local law, hold the public hearing, and then continue this discussion after you've received public input.
That's
I
fine.
mentioned that just seeing that it's 5 to 8 and you have a couple more items on your
I
agenda.
understand.
I'm good with that. Go to public have a public hearing, set a public hearing.
Yes.
With the 245 and hear from the public.
And you have the ability to modify it before you adopt the law, so that gives you the flexibility. And you would set that hearing for August 5th.
Okay.
If we move forward with the public hearing, I'm fine with leaving that question open and getting public feedback. I'll also, I've stated my perspective on it. In terms of the landlord exemption, I would like to move forward to a public hearing with no more than one number of units as our definition.
So let me understand that. That would say if I have an accessory dwelling unit, that would apply?
Yes.
Yes.
Okay. I don't support that. I support that we go with the state default to public hearing and see what the public says.
I think if you only had the one accessory unit, that you would be covered, right? It's more than one, is it?
Correct. It's more than one, yes.
Zero is not an option.
Correct, right. So one would not be, it has to be two or more.
Right, so you'd have to have either a double ADU or another unit in addition to your ADU. But I hear your point, Lee, I'm just clarifying the definition.
So again, I just don't see us being in the position to tell local landlords who don't have a lot of units as to why they particularly need to be supporting folks with their retirement or whatever else they're doing with, those units. I'm struggling to see why that group was exempted by the state and by New York City, and that somehow we don't feel that we have anyone in that group or that no one in this group in Beacon deserves any help.
I'm also fine, like Paloma, to go to public hearing with one unit, but I defer to the group, so I don't know. It sounds like what you said, Pam, that you feel like you want to get more public input before you change what we have, and I'm fine with that, too. If you feel differently, say that. And then, Jeff, I don't know if you have a preference at this point.
I'm curious about the analysis that was done. I mean, 5 units? I mean, what was the analysis that was done that said that 10 is the right number? I'm not, sufficiently equipped to know what to adjust it to right now.
I mean, I'll just say I'm happy, as always, to look at additional data, but I will point out that New York City has massively higher density than smaller municipalities across the state. So the number of people affected by 10 units in New York City is by proportion quite a bit more than the city of Beacon that has smaller buildings and smaller unit sizes. And I would also point to other municipalities in our region who are closer in size to Beacon who went with a 1-unit definition.
Yeah, anyone who's lived in Queens or large parts of Brooklyn would know that in those parts of Queens where I lived before moving here, you had tons and tons of housing that were triple deckers or 4 units, one on top of the other, where some immigrant family owned the 1 unit, somehow figured out how to buy the building and are supporting themselves, don't have a 401k, and I think New York City understood that, right? And I want to make sure that we understand that as well. So.
Yeah, I lived in one of those buildings when I lived in New York City, in Queens.
Yeah, so did I in Brooklyn.
All right, so how do we want to do this? Right now, we're at the state default. Are we okay to go to hearing with the state defaults and see what people say? Obviously, we can adjust them, either of them, right?
I actually didn't hear that we were at the state default.
No, I mean, sorry, the one that's in the packet right now is at the state default, because that's how it's written, right? How do we want to do this? And again, I've proposed we stay at the state
So
defaults.
the mayor's set at the state default. Paloma suggested going to 1, and
What do the others think?
the others are yes, we
Right.
need some more direction.
I said 1 as well. I think Pam is at default. Is that how you currently are?
I wanted to hear from the public, but this is all new to me. I was not, so I'm listening to Paloma and learning some things, but I'm also listening to Lee and understand that, it's, and I need to research more myself.
Yeah, with the understanding that we can adjust, I'd say stay at the state default in our packet. And hope everyone's listening and comes and comments.
Yeah, exactly. We'll get plenty of comments, I'm sure. So,
Okay.
Okay, so
All
that
right.
seems to be the consensus, is to stay with the state default and continue the discussion.
all right.
Okay.
Okay, so that's that one. We've got a local law concerning soil stabilization. Nick, hopefully you're going to tell us what that's about.
I am. It's Plastics Free Month in July, so use less plastics. And out of that comes this local law, which is suggesting that, and would require that future erosion control practices for soil stabilization make sure that the material is made of natural fibers that degrade, as opposed to being permanent plastic that will remain there. Your administrator brought this to our attention. We spoke with based upon some comments from the public, and then we looked at this, spoke with the city engineer, and developed this language. This is an amendment to the zoning code, so it would require referral to the planning board and the scheduling of a public hearing before this council, which we'd suggest to be scheduled for August 19th.
And so it sounds like this didn't come from a state requirement. This was something that, was proposed would be a good fit for Beacon, sort of in our environmental leaning.
That's correct. It was actually an exemption. In some situations, the state requires that it must be plastic, for example, if it's in stream or other areas where
Because
it's
you need something a little stronger,
sturdier.
maybe?
Yes.
Or
I don't know,
proven
Chris, if you
stronger.
have something
And
else?
this would only be relevant to materials that are left in place, like your storm
Erosion
control.
control fencing.
Fencing is fine. It came about because we had complaints that people were leaving plastic mesh on the stream banks of the Fishkill Creek. It does degrade, but it does not biodegrade. So we asked our engineer to look into it. He thinks there are feasible alternatives. When I did rail trail projects in Ulster, we could only use biodegradable because we were in the New York City watershed. So it can be done. It's a little bit more expensive, but it's the right thing to do.
Great, thank you. Yeah, I personally am fine for this going to public hearing, and thank you, Chris, for looking into this.
Yeah.
Agreed.
And Dan raised this as well. I do want to give Dan credit
Oh,
for
great,
flagging
thanks.
this.
And so our next step is to set a public hearing and make a referral to,
The county and the city planning board and schedule a hearing for the 19th, and that's it. Resolution is in your agenda packet.
everybody good?
Yes.
Yeah.
Okay. And then the third one, local law, is concerning the T district and dimensional regulations in it. You want to
Yes.
tell us about that?
I will. So this is also an proposed local law. In your packet is the local law and a memorandum explaining the reason. So this is sort of to correct an oversight in the zoning code that was brought to our attention. Townhomes are a permitted use in the linkage district, the RD district, and the transitional zoning district. So you have a schedule of use that says what can you build, and then you have a schedule of dimensional regulations that says how many, how far setback, et cetera, et cetera. And the dimensional regulations have setbacks and allow in the linkage and the RD zone townhomes. Townhomes are a permitted use also in the T district, but there are no dimensional setbacks allowing the, what the dimensions would be for a townhome constructed in the T district. So what we've done is propose an amendment that will carry through those dimensional regulations for townhomes in the T district that are consistent with the RD district. We've reviewed this with your planner Natalie and with Bruce Flower, the building inspector, who both agree that this is an appropriate correction to make to the zoning code. And also there is, as you'll see at the end of footnote E, some additional language that is added that was left off when the law was codified a couple of years ago. So this will correct a Scribner's error.
I had a couple of questions, just not, I think the law itself sounds fine, but just technical things. So I thought in your memo, you said it applied to both the T district and L zoning. Is that linkage?
Linkage, yes.
But in the law itself, it just says or T district. Is that because this section doesn't need to refer to the linkage district?
Exactly, because if we go to the dimensional table, it already has for the linkage district a separate setback that shows 0 to 10 feet. So therefore, footnote E only applies to the RD district. Footnote E doesn't apply to the linkage district.
And footnote E does not apply to the T district then either?
Correct, right, and that's why we're adding the T to the footnote E. So dimensional regulations for townhomes in the linkage district are addressed specifically in the table. Dimensional regulations for townhomes in the RD district are regulated in footnote E. To make this simpler, we're just saying add T to footnote E so that footnote E applies to both RD and the transitional district.
Wait, the last thing you just said, footnote E does apply to the T district?
It does, no, it does not. We're saying amend footnote E to include T, so it would now say RD and T districts.
Okay.
Sorry for the,
I appreciate you going around
Yep.
with me. I
And if
spent a
you-
lot of time looking at that.
and if you look at the linkage district where it says 0 to 20.
Oh, I
For the
see.
setback, that then applies to townhomes that would have a 0 dimensional setback.
Right, okay.
And so that's why we're only adding the T to the E for the RD inclusion as well.
Thank you.
You're welcome. Who says land use isn't fun?
Say that 5 times
Relatively
fast.
poetic.
Yeah. So Mayor, if the board is, council is comfortable with that, scheduling the hearing for the 19th, referring this to the planning board and county, and so the planning board could review it at its August meeting that occurs before the hearing on the 19th.
Okay, any comments from others? I'm still trying to get my arms around this.
Yep, so if we look at the attachment 1, which is the dimensional
Yep,
regulations.
that's where I'm looking.
Okay, so you'll look at the L district, it says minimum yards, 0 to 20 or 0 to 30, so that would permit a townhome, an attached townhomes, right? Because if you're an attached townhome, you don't have a setback, you're connected to one another. For the RD, you'd have to go to the footnote E. And that would now apply to the T district as well. Because it was already previously determined that townhomes are appropriate uses in the transitional district. And that's found in the table of uses.
Okay, so in our packet, footnote E is shaded. Would we also be saying we're going to amend the table to include the superscript E in next to T in the column for zoning district?
Correct, yes.
Okay.
Yes. So in the local law is the amendment to amend footnote E, and it would also, in section 1 of the local law, says add footnote E to the T zoning district column. So there are two amendments to the table. One is to add the footnote E to T, and the second is to amend E, footnote E, to include T.
So it's not in what we're seeing in our packet currently
Yes,
attached to
but-
E.
Correct. It's in the proposed local
But
laws
it's
where
in
you'll
the
see
law
what's
is what
proposed.
it's-
Yes, thank you. It just took
Okay.
me a minute.
Now,
Well, a
now
couple of
I'm
minutes.
fully, I appreciate you, Lee, asking again, because,
No, there's clearly, I had not explained it well, so I apologize.
It's okay.
I should have started with the local law.
Thank you. It's just I was getting lost in there, so thank you.
Yes.
Okay. Any concerns on that? So again, our objective here is to make a referral and to set a public hearing. That's going to be our next step.
Yes, and that resolution is in your agenda packet.
Okay, great. Okay, and then we've got 3 more items which involve the chief. And Chris, do you want to introduce it, or are we just going to hand it to the chief on these 3? This is the appointment of Tom Durkin to sergeant, of Kelvin Gray to sergeant, and also presentation of the 23 annual report.
Yeah, just quickly on the promotions, our Detective Sergeant Jason Johnson is retiring on Friday, and so we are proposing to promote Thomas Durkin, to that position. We also, at the end of the month, are going to be losing Joseph Conti, who's a sergeant. So we're proposing to promote Kelvin Gray, who's currently a detective, to the position of sergeant. And Tom can talk about both of their backgrounds. I do want to note that the council spoke to both of the applicants in executive session at the last meeting. Go ahead, Tom. Thanks.
Sure. So again, it's lovely to be here. And again, like I mentioned last, am I on or
You got to pull it closer.
Gotcha.
Otherwise, Ben gets mad.
Again, one of the best things about this job is coming up and seeing people that you've seen come up through the ranks be promoted. So do you want me to go Durkin first and then I think that was the agenda?
Yeah.
Okay. So I am proposing the promotion of Detective Thomas Durkin to the rank of Detective Sergeant. Detective Durkin is our senior detective in our detective bureau and has extensive experience in the community and with the department. He graduated from Beacon High School in 2010 and went on to earn a degree in sociology from Mount St. Mary's College. During the course of those studies, he actually participated in our internship program in 2013. He also worked as a part-time dispatcher here from 2014 to 2015 until he was hired as a police officer. He served as a very reliable patrol officer who was very well regarded by his fellow officers and supervisors through that time. He was made a field training officer and was relatively quickly assigned to the Detective Bureau in 2020 and fully promoted in May of 2021. In the Detective Bureau, Detective Durkin received training in child first forensic interviews, became a certified evidence custodian, attended advanced juvenile training, FBI basic photography, and crime scene photography training in the FBI crime scene technician school. As a detective, in addition to his regular criminal investigation duties, Detective Durkin manages the department's medication and syringe drop boxes. He also serves as the department's evidence custodian, which involves an incredible amount of responsibility, as he has to be able to manage and account for every piece of evidence in the department's possession. In that capacity, he's also responsible for ensuring that evidence goes out for and is returned from all of the laboratory testing that's required. And he's also one of our primary detectives assigned to the completion of discovery, the process in which the department ensures that all items in the department's all items of evidence are turned over to the prosecutor's office in a timely manner. This assignment requires excellent time management skills. In addition to those responsibilities, in 2022, Detective Durkin was awarded by Mental Health America for meritorious service for assisting with locating and de-escalating an individual who had called in a man with a gun while himself fitting the description that he gave. It's highly likely that this individual would have been attempting suicide by cop, and we're thankful for the response which was provided. With his experience starting as an intern and working his way up to be one of our senior detectives, and considering the fact that he already held and managed a great deal of responsibility in the Detective Bureau, I believe that Detective Durkin is uniquely qualified to serve as our next detective sergeant here at the Beacon Police Department.
Any questions?
Can you say a little bit more about the management training that individuals get as they move from being what I assume is more sole contributors to actually managing a team, and how that works?
So there are actually two kind of trainings as far as it goes that are required within a certain amount of time by state law. One is the basic course for police officers, so that's the police academy. And then anytime somebody's promoted to a supervisory position, there's a 3-week school that's required by the state. It's the course in police supervision.
Great, thank you.
And there's no additional maintenance that's done in the course of that position being held? Just that 3-week training, that's it?
No, I mean, our detectives go through regular updates and training and so on and so forth. There's nothing specific to, hey, you're a detective sergeant and you have to redo these things.
You mentioned that the 3-week school is required by the state. Are there optional trainings that are offered to officers that they can opt into?
Yes, like I was saying to Jeff.
Similar.
Yeah,
I guess mean specifically around a promotion like this and management training.
Yes. And actually every year we also work in some kind of supervisory training. Like for example, this last year we did updates with the DA's office. We had them come down and do some legal updates with our supervisor just to keep them up to date.
Want to tell us about Calvin Gray?
For sure. I'm also obviously recommending the promotion of Detective Calvin Gray to the rank of sergeant assigned to the Patrol Division. Detective Gray was born and raised in the Bronx, New York, and attended Cardinal Hayes High School before transferring to and graduating from Beacon High School. He went on to work as a forklift operator for New England Motor Freight, a trailer unloader for UPS, and a home health care attendant for Unlimited Care, Inc. From 2012 to 2014, he was also a coach for the Beacon High School JV football team, where he was actually one of the coaches for our now police officer, John Underwood. In 2014, Detective Gray was hired by the Village of Wappingers Falls Police Department, where he served as a patrol officer until he was hired here in Beacon in July of 2016. Here he served as a patrol officer for approximately 5 years, where he received good reviews on his handling of calls and was also well respected by his supervisors and his fellow officers. During that time, he was also made a field training officer. He's a child safety seat technician, and in 2021, he was assigned to the Detective Bureau and then fully promoted in August of 2021. In the Detective Bureau, in addition to his regular criminal investigation duties, Detective Gray is also one of our primary background investigators for new hires, helping ensure that we hire the best possible candidates that we can. And he is also assigned to complete discovery, which I kind of already explained to you guys. Detective Gray has also shown his leadership skills by holding leadership positions outside of the department as elected by his fellow officers. He's the treasurer of the PBA, and while I'm no longer a member due to my position, I will say that he's done a very good job of managing the finance of that organization. He also founded and serves as president of a motorcycle club for first responders. In addition to providing a recreational outlet, the club raises money to donate to families of fallen first responders. Detective Gray's experience both in patrol and the detective division and his natural leadership abilities make him an excellent choice for the position of patrol sergeant in the City of Beacon Police Department, and I'm confident that in that role he will continue to use those skills in those areas to benefit our department.
Thank you, Chief. Any questions from anyone or comments? And our next step on these two is appointments at the scheduled next meeting. Is it this meeting? This meeting? Yeah,
Correct,
this
yes,
meeting.
it's on tonight's agenda.
Got it. Anyone on the council have any concerns with appointing them at this meeting? Okay.
No, I don't.
Okay, great. Okay, and the last one is also yours, Chief. You have an annual report you want to give us.
That's correct.
Okay.
I'm assuming you don't want me to read through the whole thing.
No, I want you to kind of summarize what's in there for us.
Yeah. As part of the State of New York's police reform initiatives launched in 2020, you, among other things, formed a police advisory committee which called for further transparency and sharing of various statistics to keep the residents of Beacon informed of the work of Beacon Police Department. Part of that effort was to reinstitute the production of an annual report. And while various initiatives and staffing changes unfortunately delayed its production and publication until now, I hope that this annual report provides some key insights and information community needs to keep its police department, keep informed about its police department. So in that report, we went through a few different items. I outlined our various community participation first. I know that is a concern of people of Beacon. They do want to see their police officers out among the community. We then talked about staffing levels. In 2023, we kind of started and ended at the same staffing level, though we're budgeted for 36 sworn officers. We were at 33. Unfortunately, as you guys may be aware, that number is starting to trend down. And then went into some notable police incidents. Obviously, this isn't a full summary of all of the police incidents, but these are kind of the highlights of the major incidents that we handled. I then covered the various trainings that we did throughout the year, and then went into some yearly activity and crime statistics. We talked about calls for service and traffic enforcement, as well as getting into some crime-related issues. So we then outlined the reported violent offenses, reported property offenses, arrests compared to traffic stops, and then some data for some specific cases such as aggravated assault, simple assault, robberies, rape, weapon law violations, burglary and vandalism, identity theft, and possession of stolen property, as well as larceny. And then in the next section of the report, we talked about use of force, gave some use of force statistics, what percentage of use of force incidents occur during our arrests, what percentage they represent for total police interactions. We also did a comparison of what we consider a use of force versus what the state actually considers use of force. And then we jumped into traffic enforcement statistics and then ended on domestic violence statistics.
And just, I know the council knows this, but for the public, the city's use of force of policy is stricter than the state's use of force policy. We have to report if there's anything other than non-compliant, compliant handcuffing. And the state has a much higher threshold.
Is that in our code, or is that currently written into our code, our level of
No, it's
use
our
of force?
policy.
Our
It's
policy
our-
we
it's our
have,
federal
okay.
policy.
Related to data too, can you talk about what is, so use of force is a good example of what actually exists within Beacon, sort of in general, is the data that you're gathering stuff that, data that the state requires, that the city kind of does on its own? For example, you talked about tracking arrests differently, because sometimes those disappear if they're sealed, and so it seems to be there's some discretion, so I'm wondering kind of how that works.
Yeah, so I thought that in the report, I think that the residents of the city would get a better idea of what their police are actually doing if we report kind of all the arrests we make. So even if the arrest is sealed due to the suspect pleading out to a lower offense, I think that the residents probably want to know, hey, but did the police make an arrest? And so that's how I use that data. Now, unfortunately, kind of going back, right, we went back to 2019. Unless you're tracking it monthly, you lose something there. So that's why I've kind of changed the way that we're tracking it. So right now, I'm tracking all of this data monthly so that I can give you a more accurate picture going forward.
I think you've spoken to it when we were talking about staffing issues, but we're down in staffing. You said it's an issue. And from a revenue perspective or from an expense budget perspective, it's more expensive to have less officers, correct? I mean, just because of overtime requirements and the like, or is it neutral? I mean, where does it stand in terms of?
So there's probably, right, a certain point where you're saving money on overtime. I think we're hitting the point where we're not, right? Because benefits are involved, but now we're getting to a point where we're starting to force people on shifts. Last weekend, we were bordering on maybe having to force people on triples. So we're getting into kind of shaky waters in our staffing.
And Jeff, we'll be talking to the council more about, we have some hires that we're trying to do, but just to give you a picture, we have 36 sworn officers. We, at the end of this month, are going to have 8 vacancies out of 36. We have 2 that are on 207C, which means they're on injury, so they're not available to the shift. And then we have 2 that are training, doing field training. They've been great, they're filling in for events, but they don't count towards shift. So we literally are doing overtime every week now just to fill basic shifts, not to do any kind of special things. Anytime we do training, it automatically invokes overtime. Anytime that we have, you know, an officer has to go to court, an officer has to, calls in sick, we're ending up hitting overtime. So we've really got to make a focus on getting our staffing up. We had been doing well. Again, the retirement wave has really hit us, and we're trying to set up this police department so that we don't continue to lose people and we continue to start to rebuild. We've got to get beyond the number that we have today, or we are not sustainable financially.
Yep, that's what I'd heard previously. The 2 of the charts stand out as being kind of exceptional in terms of their numbers. The traffic stops seems to be like a 50% increase between 2022 to 2023. Just kind of curious the reasoning.
That's your city administrator.
You're out there doing it yourself, Chris?
No, I'm out there pushing for enforcement, because that's one of the biggest complaints we get is about speeding, running traffic lights, running stop signs. So the community asked for this, and again, we had taken a pause during COVID because you wanted to minimize interactions between people, and there was a lot less traffic.
So if we had 2021, 2019, you'd see the pattern.
That's good.
Getting back to
I've had
2019.
I've had contacts from constituents concerned about traffic calming in certain areas too. And so I mean, it's good. And they claim that there's no actions where they're seeing. So I'm glad to see that increase and hear that reason.
Every time there's a complaint, we try to adjust. I mean, we don't have staffing to put people on dedicated enforcement all the time, but as we can, like we had an issue over on Wilk Street. How many tickets did we issue? 100, and it's out there now that you go 15 miles an hour on Wilk Street, and if you don't, you get a ticket.
I see in the report related to traffic, there was a comment right at the end to increase the output and precision of our traffic enforcement measures, and I'm curious if you and your lieutenants who might be managing this on a day-to-day basis and sergeants have any thoughts yet about how you might approach that, what you might mean, because yes, we get citizen complaints, and you know that you can't necessarily chase everyone, and also how do you prioritize within those requests?
I mean, what we generally do is, as citizen complaints come in, you kind of focus on an area for a while, saturate that area, and then you start to see a little more compliance in that area, and then you move on to the next complaint. But you try to get somebody in that area as they're available. One thing that I did notice doing this is that when we were at our highest point in traffic stops in the data that I reviewed, we weren't necessarily at our lowest point in traffic accidents. Our traffic accidents have trended now down since last year. I'd kind of like to see another year of data to see if we're getting the bang for our buck, or if we need to kind of approach it from a more data-driven standpoint. I mean, as far as what our lieutenants are doing right now, we're busy. I've got one lieutenant who's spending most of his time hiring people, and the other lieutenant's spending most of his time filling overtime. And we're kind of, again, when we're short, we're kind of in that loop of it's harder to kind of do the big picture planning because you're managing the day-to-day operations.
Right. Related to traffic stops, I know that as far as I understand, Beacon doesn't currently track racial data, which I know is something that lots of other places have pushed for. And I'm just curious if you can talk about the challenges with that, or if it's ever been considered, and kind of something that it's something that we've been asked as individuals on the council, and just what we should know about the reality of doing that.
Sure. I mean, I think one of the big challenges there is that it's very potentially escalatory to a traffic stop, right? A traffic stop should be a relatively brief interaction. But if we're kind of asking our officers, because they can't always tell, can you gather the person's racial data? If a police officer goes to you and says, okay, what is your race? And you answer them, and then they come back with a ticket, that's not making for a good situation in that traffic stop. Even I know during the advisory committee, they had asked our mental health expert to record the racial data of the people he was interacting with, and MHA didn't want to do it because they felt like asking that question was going to be escalatory in their situations as well. The state could make this easy for us, right? They could just have people put it on their licenses like they do their eye color and their gender, and they haven't done that. And And, you know, if people want that data, I would suggest kind of trying to approach it from that angle, because it would kind of take the interaction out of the traffic stop, and then we could just collect the data at a more concrete level.
Thank you.
Yeah, the one interesting one I see is the use of force one, because this was new data for me. So the state requirement for what you have to report over 5 years, we averaged 5 a year. But our own standard of collecting more than the state standard of what's considered a use of force, we're doing about 25 a year, right?
Yeah,
and,
that's better. Yeah, that's
and the difference is, what kinds of things do we have in our standard that aren't in the state standard?
So it's more an issue of, right, Chris kind of hit on it, but our standard is any use of force greater than compliant handcuffing we consider a use of force. So if the police officer tells you to put your hands behind your back and you don't, and he grabs you and you pull your hands in front of you and he brings you to the ground, or so on and so forth, we consider that a use of force. The state does not. So the state actually, reportable incidents are when an officer engages in conduct which results in the death or serious bodily injury of another person, when an officer brandishes, uses, or discharges a firearm at or in the direction of another person, when they use a chokehold or a similar restraint that applies pressure to the throat, windpipe of a person, or in a manner that may hinder breathing or reduce intake of air, when they display, use, or deploy a chemical agent, and when they brandish, use, or deploy an impact weapon, including but not limited to a baton, billy club, flashbang, etc.
And just to understand, so if there is a use of force report taken in Beacon with our lower standard of what, you know, and gathering more, that means there's a review of that incident.
That's correct, yes. We treat them all the same as far as the level of review.
Okay, thank you.
One other data question I had, I'm trying to scroll to the right page now, but it was in regards to mental health calls.
Yes.
And I believe the data just went back the last 2 years, but I was wondering if you noticed any trend of an increase in calls once we started having our MHA worker, which was in 2022. So there'd
Just
be,
grabbed it.
I think I found on page 7, thank you. Sorry, I scrolled past it.
Yeah, so this was the monthly trend. You know, 2022 to 2023, there was a decrease.
Right.
I don't know that there has been a increase since we've had our mental health caseworker. You know, I guess if
Or a
anything.
trend either way.
Sorry?
Or a trend either way.
Right.
Yeah.
I mean, one would hope, I guess, to some extent that they would decrease, right? Because
Sure.
if it's going well, that means that it should be decreasing. But we don't have a long enough trend of data to kind of really know at this point, right?
Because we weren't collecting mental health incident data before 2022?
No, we did, because we signed the contract with Mental Health America in February, late February of 2021. So we had,
Right.
we had the actual term is mental health worker intensive case manager.
Right.
Was on starting in March. So we had most of that year too.
Sorry, thank you for, having that level of detail on when Lashavius started, but I think my question was on if we were tracking the number of mental health calls before 2022.
So as far
I'm
as
assuming we
tracking
were,
goes,
but, yeah.
I would say no, we weren't, right?
Okay.
It's not that we didn't have the ability to gather that data, but we kind of got the idea that, hey, people want this data publicized in the reform committee. And so
I see.
I kind of gathered what I could gather with some expediency, because we were kind of late in the game on this. If there is interest in that trend, I can start producing that for next year's report.
Yeah, I think having a third data point would be great.
We're at 8:30. Any last questions by folks?
I just want to thank Chief Figlia for putting this together in such short order. They've had a lot going on in the department, and thank you for taking the time to do this.
Thank you.
Yeah, thank you. And I would just make one request that this report be added to the City of Beacon's Police Department page, so it's just that much more accessible to the public. I know there's already a lot of resources on that page, but
Yeah, and I look forward to the 2024 report. Maybe before July 2025, but we'll see.
Well, I had a month, so. All right, thank you, guys.
Thank
All
you.
right, thank you.
Thanks.
I'm going to suggest we take like 5 minutes, and then we'll start our regular meeting. Is that all right?
Yeah,
Okay.
that'd be good.
So if the audience bears with us for a couple minutes, we'll be right back.